I want to first start by saying that if you are guilty of sex trafficking, you deserve a very long prison sentence, if in fact you did the crime. If you make a false allegation of sex trafficking, you likewise deserve a very long prison sentence. Period. End of story. Just want to put that on the table. This is in no way excusing any behavior from anyone who would act inappropriately, criminally, and traffic women. It's absolutely abhorrent and absolutely disgusting. In the federal trial of the Alexander brothers, one charge stands alone. Count 2. It isn't about a conspiracy. It isn't about a sprawling enterprise. It's about one man, one woman, and one weekend in the Hamptons nearly 15 years ago. The government's case against Tal Alexander for sex trafficking rested entirely on this single count. There was no DNA, no police report, no corroborating witness to the crime itself. There was only the testimony of Lindsey Acree. And under the bright lights of a federal courtroom, that testimony collapsed. This isn't a story about a simple he said, she said. This is a story about a case that was built to fail. A judge who said on the record that Acree's story was, quote unquote, all over the place in reference to her testimony. This is how count 2 imploded. To understand how the case fell apart, you first have to understand the story the jury heard. On direct examination, prosecutor Andrew Jones walked Lindsey Acree through her account of Memorial Day weekend 2011. Acree, then 25, was invited by a new friend, Hannah Boulos, to spend the weekend at her guy friends from Miami's house in the Hamptons. That friend, she said, was Tal Alexander. She testified that she and Hannah took the train out, where Tal and another man picked them up at the station. Tal drove them to a one-level house with a pool, a hot tub, and a gym, and sauna downstairs. The house was quiet. No party, no crowd, just the four of them. They got in the hot tub. Acree says she had just a few sips of wine. Quote unquote, 3 sips, half a glass, when she started to feel heavy, slow, zombie-like. Tal suggested the sauna. She followed him in what she described as slow motion. Inside the sauna, she testified, Tal pinned her down on the bench by the back of her neck. Her memory from this point on, she said, was like a flip book with big pages missing. The second man then walked in. She described a sense of dread, a brace for impact. She was led from the sauna into the gym. She was too weak to lift the weights the second man handed her. She crumbled to the ground. Tal left and came back with a tripod. She remembered the straps of her bikini being pulled off, her body being manipulated. One man behind her, Tal in front. Both of them laughing, she said, as though it were a game. She woke up alone on a lawn chair by the pool, her bathing suit messed up, cold and confused the next morning. When she walked inside, Tal told her, stone-faced, that she'd, quote-unquote, had quite the night, but needed to leave. As she was walking out, she saw 2 very young girls arriving to take their place in that room. That image, she said, is the reason she spoke up and is the reason she's in court. On its face, it's a horrifying story, and it was the entire foundation for count 2. But a foundation built on sand cannot stand. The first crack in the foundation was the house itself. Acree was clear on this point. Hannah told her they were going to, quote-unquote, Tal's house. On cross, she doubled down. She said it was Tal's house. The prosecution's case depended on Tal having a location he controlled, a place he could bring women to. But the defense came with receipts. Literally. At a sidebar with the jury out of the room, defense counsel Deanna Paul revealed the truth about Tal Alexander's 2011 summer rental. His share house was at 26 on the Bluff in Sag Harbor. The lease, which the judge allowed into evidence, didn't start until June 15, 2011. Memorial Day weekend, the date of the alleged crime, more on that later, was May 28th through the 30th. The lease started more than 2 weeks after the alleged assault. As Ms. Paul told the court directly, Tal had a share house that started on June 15th that Rafael Avigdor brokered. From Memorial Day weekend 2011, when Tal is alleged to have sex trafficked Lindsey, he was in fact scrambling to figure out where he was staying. He didn't have his own house to lure anyone or invite anyone or harbor anyone. The prosecution's response was to say that people go to the Hamptons without renting a house all the time. And technically, that's true. But that's not what their witness said. Their witness said it was Tal's house. The government had identified a specific crime scene, and the defense proved Tal had no lease on any Hamptons property until 2 weeks after the alleged crime. The crime scene, the very location of the charge, had vanished. If the location was a problem, the date was a catastrophe. The original indictment didn't say Memorial Day weekend. It said July 2011. So why did it change? Because of Eric Yechezkel, the man Acree identified from a photo lineup in October 2024 as the second assailant. After Acree picked him out, Yechezkel's lawyer informed the government of a problem. Well, actually informed Acree's civil attorney of a problem. His client had an alibi. Department of Homeland Security records confirmed that Eric Yechezkel was out of the country in July 2011. It was only after the government learned about this alibi that the indictment was amended. The date of the crime was moved from July to Memorial Day weekend. On the stand, defense counsel asked Acree about it directly. Quote, "Miss Acree, isn't it true that you learned the individual that you identified to the government was actually out of the country in July 2011? And only then did you look for this email with your mother and change your date to Memorial Day 2011. Acree denied it. She claimed she had consistently said it was a holiday weekend. But the documents don't lie. The indictment was changed, and it was changed to escape an alibi. The date wasn't based on Acree's memory crystallizing. It was based on the government's need to move the goalposts. The prosecutor himself acknowledged at sidebar that July appeared in the original indictment, and after that, additional information came up, they changed it to line up with Memorial Day. Even the judge noticed. With the jury out of the room, Judge Caproni made a pointed observation about Acree's testimony. Her words, "I confess that her testimony was somewhat all over the place." That is a judicial understatement. But coming from the bench in the middle of a federal trial, it is not nothing. The problems with the second assailant didn't stop with the date change. On the stand, Acree's testimony about Eric Yechezkel became even more tangled. She had identified him in a photo lineup. She had named him as John Doe in her civil lawsuit. But when the defense asked her whether she knew the man she identified was named Eric Yechezkel, she said no. When asked whether she had served an individual named Eric Yechezkel in her civil case, she said, quote, "I didn't serve anyone. The person's name is John Doe. There has been nothing filed or anything with anything other than John Doe," end quote. This is difficult to reconcile with the documentary record. The defense established that Yechezkel was in fact served in the civil case. Acree's denial of even knowing his name, despite having litigated against him, is either a remarkable failure of memory or something more concerning. And then there is the final blow. The defense argued that Yechezkel wasn't just out of the country in July, he was also out of the country on Memorial Day weekend. If that is true, it means the government didn't just move the date from one impossible timeline to another. It means that the man Acree identified as the second assailant wasn't there at all. He is a phantom. And if she was wrong about him, what else was she wrong about? With no physical evidence, the prosecution needed something, anything, to corroborate Acree's story. They tried to find it in an email she sent to her mother just days after the alleged assault. They presented it as an outcry, a contemporaneous record of her trauma. But then they read it to the jury. Quote, "The Hamptons was a little crazy. My friend Hannah and I went and stayed at these guys from Miami's house who ended up being total assholes. It was a good time, though. Just learn that it doesn't matter where you are or how glamorous the place is. If you're with creeps, it isn't fun." End quote. Read that again. She calls them assholes and creeps. She does not call them grapists. She does not mention being drugged. She does not mention being assaulted. She says the opposite. It was a good time, though. Acree explained on direct that she wrote that to protect her mother from worry, that she didn't want to say the words explicitly. That explanation may be emotionally understandable, but an email that says it was a good time is not an outcry. It is, at most, a vague reference to social discomfort, and at worst, a document that directly contradicts the story she told on the stand. To make matters worse, the defense revealed that Acree didn't produce this email to the government until November 2025, just 3 months before trial, and only after the timeline of the case had already been forced to change. The only piece of contemporaneous written evidence was late, ambiguous, and for the prosecution, deeply unhelpful. Here is something that didn't make the headlines but should have. 3 days before Lindsey Acree took the stand, Saturday, February 7th, 2026, she met with the government and for the first time in 18 months of cooperation, disclosed specific graphic sexual acts she had never mentioned before. Not in her initial FBI interviews, not in her civil complaint, not in the amended complaint, not in any of the multiple meetings she had with federal prosecutors over a year and a half. 3 days before the trial, that was the first time. Defense counsel Deanna Paul pressed her on it directly. Quote, "Isn't it true that on Saturday, 3 days ago, before your testimony, you told the government about specific sex acts that you had never in the last 18 months mentioned before?" Acree's response was that she hadn't wanted to use vulgar language. She had talked about it before, quote unquote, in less vulgar terminology. But the record shows it wasn't just a matter of word choice. The day before that, Friday, February 6th, she told the government for the first time that she could feel that she had been sexually assaulted but could not remember a specific act happening. Then, the very next day, she described explicit acts in detail she had never described before. The story didn't just grow over time, it grew in the final 72 hours before she testified. This pattern of escalating disclosure runs through the entire case, and it starts well before the government ever got involved. In July 2024, Acree gave an interview to the New York Times. She spoke on the record under her own name, knowing it would be published in one of the most widely read newspapers in the world. And here is what she told them, that after stepping into the hot tub, she drank wine and then, quote unquote, "it's just nothing." That other than a slight memory of being pinned down in a sauna, she remembered nothing else for at least 24 hours. On the stand, she confirmed those were her words. She said yes, that's what she told the Times. On cross-examination, defense counsel asked her directly, did she authorize her attorney to tell the government in September 2024 that she woke up and could tell she had been raped but couldn't remember a specific act happening? After some hesitation and after being shown the document, she said yes. So in July 2024, she told the Times she remembered nothing. In September 2024, her attorney told the government essentially the same thing. And then in June 2025, she coordinated the publication of a Miami Herald article to coincide with the refiling of her civil lawsuit under her own name. And that article told a completely different story. The Miami Herald version was not a vague account of waking up confused. It was a cinematic narrative, being checked on to confirm she was unconscious, being graped in multiple rooms of the house, a tripod, laughter, her hair extensions being pulled from her head. Details that were nowhere in the Times interview. Details that were nowhere in what her attorney told the government 2 months after that interview. Acree's explanation was that the Times reporter chose to leave out graphic details out of respect for her dignity. But the defense established that her attorney had conveyed a nearly identical account to the government in September 2024. And that account was also missing those details. The tripod, one of the most striking details in her direct testimony, was not mentioned until she filed her civil lawsuit in February 2025, more than 6 months after she first met with the FBI. The detail that both men R-worded her simultaneously was first disclosed in the amended civil complaint filed in May 2025. The detail that Hannah was present and may have taken photographs was also new to that amendment. Each wave of legal proceedings brought new details that had not appeared in the ones before. And then, in the final 72 hours before she testified at trial, the most explicit details of all emerged. Acree's explanation was that these things were hard to say out loud, that the trauma made it difficult to put into words. That explanation may be genuine, but from an evidentiary standpoint, a story that tells the New York Times it's just nothing, tells the government the same thing 2 months later, and then builds into a detailed account of being R-worded in multiple rooms with a tripod in specific sexual acts, with each new version more graphic than the last, is not a story that has been told consistently. It is a story that has been constructed piece by piece over 18 months. The government's last hope was Julia Baldwin, Acree's former roommate. She testified that when Acree came home from that weekend, she said, quote, "The most fucked up thing in her life had ever happened," end quote, and couldn't talk about it. Years later, at a book club in 2017, Acree mentioned Tal's name and said 2 men were involved, that it happened in the Hamptons, that Hannah was there. It's important to note that Harvey Weinstein was taken down during the Me Too movement, first came out October 5th, 2017. So this is as the Me Too movement is emerging. But Baldwin never said Acree told her she was R-worded. She never heard the name of the second man. She never heard Acree describe being drugged. The most she could offer was that Acree said, quote unquote, the most effed up thing happened over that 2 men did things together with her. That is consistent with a traumatic experience. But it is also consistent with a story that evolved significantly in the decades plus between the book club and the trial. And here's the part the government would rather you not focus on. Baldwin wasn't contacted by the government until February 17th, 2026, 8 days before she testified. She had 2 meetings with prosecutors before taking the stand, and she had already read about Acree's allegations in the New York Times and other outlets before ever speaking to anyone from the government. The risk of contamination between Acree's public story and Baldwin's recollection of private conversations is real, and it is unrebutted. There is one more layer to this. Acree admitted on the stand that when she first saw the news of the Alexander brothers, she thought a woman named Liz Kennedy, another accuser of the Alexanders, was one of the women named. She said she had to back up her story. She wanted to have Kennedy's back. That impulse to corroborate a friend, to validate another person's account, is a powerful motivator. The defense argued it could be powerful enough to shape memory itself. The government never had a good answer for that. So what's left of count 2? A date that had to be changed to avoid an alibi. A crime scene the defendant had no access to. A second assailant who appears to have been out of the country on a different continent. A story that told the New York Times, quote unquote, and then it's nothing. Then told the Miami Herald a year later it was R-word in multiple rooms with a tripod and laughter. A story that added to its most graphic details in the 72 hours before trial. a corroborating witness who wasn't contacted until 8 days before she testified, long after she'd read the story in the press. And a single uncorroborated accuser whose only contemporaneous document says, quote, "It was a good time." This is more than reasonable doubt. This is a case that has collapsed under its own weight. The government staked the only charge exclusively against Tal Alexander on a story that the facts, the documents, and the timeline refused to support. The implosion of count 2 was not a surprise. It was an inevitability.